Welcome everyone. My name is Dr. Leopoldo Parada. I'm a lecturer in tax law at the University of Leeds, and I'm co-hosting this series together with my colleague and friend, Professor Lederman. So now she's going to present herself and our speaker of today with the fantastic topic that we have to discuss. So over to you, Leandra.
Thanks so much, Leopoldo. I'm Leandra Lederman, the William W. Oliver Professor of Tax Law at Indiana University Maurer School of Law, and it's my pleasure to introduce today's speaker. Emily Cauble is a professor of law at DePaul University College of Law, where she has been since 2012. She's written a number of articles on various aspects of tax administration and on partnership taxation. Before joining DePaul, she taught at Michigan State and was a visiting assistant professor at the University of Illinois. Before beginning her teaching career, she worked in the tax transactions group at Mayer Brown. And today she'll be presenting electing second choice tax outcomes. With that, let me turn it over to you, Emily. Thank you.
Thank you. And thank you so much, Leandra and Leopoldo, for the opportunity to present here. I've really enjoyed all of the work that's been a part of this series, and I'm looking forward to getting your thoughts on this project. I'll bring up my slides. First, by way of a little bit of background, I came to this project with the idea of thinking about ways that taxpayers use self-help to cope with uncertainty about tax outcomes. And I decided to focus on one particular device that taxpayers use this way, protective tax elections. What is a protective tax election? So in a variety of contexts, taxpayers can affect what their tax outcome will be by filing or not filing a given tax election. Sometimes taxpayers might not know for sure whether filing a tax election is necessary to get the tax outcome they want, but they file it anyway just in case. In those instances, they're filing a protective tax election. I think it's useful to break them down into two different categories. The first bucket is what I call added security protective tax elections in the paper. With these, the tax outcome that follows from making the election is just what the taxpayer intends to claim no matter what. So as a quick example, you might have a circumstance where a taxpayer is not totally sure whether they filed a valid election already. They figure I'll go ahead and file it perhaps again, perhaps for the first time, just in case. Or as another example, sometimes the taxpayer might not know for sure what the treatment will be by default if an election isn't filed, but they know what they want and they figure, well, I'll just file the election. Maybe it's the same as the default, maybe it's different, it doesn't hurt to file it, I'll go ahead and do it just in case. That category is actually not what I'm focused on primarily in the article. Instead, I'm focused primarily on favorable fallback protective tax elections. Here, the tax outcome that follows from the election is actually not what the taxpayer intends to claim. The taxpayer has in mind some other outcome entirely, but they say, there's some risk that outcome might not be available. If that outcome isn't available, the election becomes relevant. And the taxpayer says, well, if the election becomes relevant, I'm better off if it was in place than if it wasn't, so I'll file it on a protective basis. This table kind of diagrams out that basic pattern. Again, the idea is the taxpayer intends to claim some outcome that is the most favorable from the taxpayer's perspective. There is some risk that might not be available. If it's not available, the election becomes relevant, and the taxpayer is better off if the election is in place. So they file the election to secure this intermediate outcome as their backup, instead of the least favorable outcome that would come about if the election were not in place. I think there are a number of different elections that fit this pattern, or at least given certain facts can fit this pattern. To give a little bit of context, I'll briefly talk about a few of the examples that I mentioned in the paper. So as one example, you could have a circumstance where a taxpayer sells some land that they've, say, subdivided, they've added some roads. The taxpayer intends to claim that the land was investment property, and as a result, the gain gets capital gain treatment, which is taxed at beneficial rates, so that's the most favorable outcome they're aiming for. but the taxpayer says, well, there's some risk taxing authorities might come in and say, actually under the facts and circumstances test that we use to decide whether it's investment property or instead is something you're holding primarily to sell to customers, this looks like it's not investment property because you did a lot of advertising, subdividing, things along those lines. In some circumstance, if that comes to pass, the taxpayer will be better off if they had in place a protective election that makes it so that the gain still gets treated as capital gain, but the trade-off is they can't include in their basis the cost of improving the roads. So it's not as favorable as what they're hoping for, but in some cases it can be better off than what happens down here if they didn't have the election in place and it's treated as ordinary income. Whereas a second example, you might have US persons that own stock in a non-US corporation. They hope and believe that it will turn out that it's not a passive foreign investment company. That's their most favorable outcome over here. There is some risk that it might be a PFIC. If it is, different taxing regimes can potentially apply. The taxpayer might say, well, the best of those taxing regimes, if it comes to it, is to have the qualified electing fund regime. So I'm going to make a protective election to have that be what happens if it turns out to be a passive foreign investment company. Or briefly, as a third example, you could have a taxpayer that sets up something that they want to have it treated as a real estate investment trust or a REIT. That parent REIT might in turn own a subsidiary REIT. Their most favorable outcome is they're both REITs. If they're both REITs, then neither of them is subject to entity level tax. But there might be some risk that the subsidiary would fail to qualify. And in case that happens, the taxpayer puts in place a protective taxable REIT subsidiary or TRS election for the subsidiary. So that means if the subsidiary fails to qualify, the subsidiary will become subject to entity level tax. So it's not as good as the most favorable outcome, but it's better than the alternative, which is that the subsidiary, if this election isn't in place and if it fails to qualify, it could in turn cause the parent company to fail to qualify. So that's kind of the pattern that plays out. Is there anything about allowing this sort of election that might be problematic? Well, one possibility is that maybe the ability to file these protectively will induce some taxpayers to take more aggressive initial reporting positions. So kind of returning to this table, if you imagine you can't file protectively, if you couldn't file these protectively, a taxpayer would essentially have two options. Option one, they could claim the most favorable outcome, but then they risk being subject to the least favorable outcome in the event that their claim is successfully challenged. Or option two, they could just say, you know, preemptively, I'm going to go with the intermediate outcome. Like, I'm going to concede that this land is not investment property under facts and circumstances. I'm going to opt for this election to get this intermediate outcome instead of risking the least favorable one. And when forced to make that choice, some taxpayers might do that. They might opt for the intermediate outcome. I think conceptually, we could think of the difference between intermediate outcome and least favorable outcome as like an implicit tax penalty that induces some taxpayers to say, I'm not going to go with the most favorable outcome because if I do, in addition to any explicit tax penalties that might be imposed on me, I bear this implicit penalty of having given up the opportunity to get that intermediate outcome. But if you can file protectively, that implicit penalty essentially goes away. You can claim the most favorable outcome, but secure the intermediate one as your backup option. And in a way, I think this is what taxpayers can do with protective tax elections is in a way similar to something they cannot do in a little bit of a different context. So, any time a taxpayer is setting up a transaction, there might be a menu of different options that they could use. One option might be to use a pretty aggressive structure, meaning if taxing authorities challenged it, high likelihood that their challenge would be successful. But if they don't challenge it, that aggressive structure might lead to a very favorable outcome. If it is challenged, it gets recharacterized in a way that maybe leads to a pretty high effective rate of tax, least favorable outcome for the taxpayer. There might be a different option on the menu when they're planning this that's like, well, here's a structure that's less aggressive. You know, there's less of a risk the taxing authorities would effectively challenge it. But you know, the outcome that you report if you use this transaction isn't as favorable as the outcome that you report if the aggressive structure goes unchallenged. And I think like with the protective tax selection example, we could think of the difference here between intermediate outcome and least favorable outcome as an implicit penalty. Right? If you claim if you use the aggressive structure and it's challenged, there may be explicit tax penalties, but there's also this implicit tax penalty where you gave up the opportunity to get this intermediate outcome. What a taxpayer might really like to do, but generally can't, is they might like to use the aggressive structure, claim the most favorable tax outcome. If taxing authorities come in and challenge it, say, just kidding, let's pretend I didn't do that. Let's pretend I used this less aggressive structure instead. Right? Generally, you cannot do that, but with the protected tax election, in a way, you get a similar benefit. You get to go with the most favorable outcome, but have the intermediate outcome be your backup. But of course, with the protective tax election, you only get to do that if you filed the election. And by filing the election, you potentially are alerting taxing authorities to, hey, this is the thing that I'm locking in as my backup option. So maybe we're okay with getting rid of the implicit penalty in this context, similar to the idea that in a variety of other contexts, explicit tax penalties might be lower if the taxpayer has done some sort of advanced disclosure. So we could think of the protective tax election as your advanced disclosure, and in exchange, you get a lower implicit penalty. And you know, why do we do that? Well, one reason we do that is if there's a higher likelihood of detection, we can have a lower penalty. And kind of connected to that, we might also think that taxpayers who file these are more likely to be taxpayers that are taking defensible positions, since filing them carries with it possibly a higher risk of detection by taxing authorities. It's probably more likely that that will be true if the tax election is accompanied by various requirements. With some protective tax elections, but not others, if you file them, there's an extended statute of limitations, so more time for taxing authorities to examine your initial position, and or a requirement that the taxpayer submit some statement explaining the justification for their initial reporting position. If those things are true, it's probably more likely that the risk of detection will make it so that the taxpayers who file them are more likely to be taking defensible positions. And I think that idea ties into existing literature that talks about different ways in which steps that taxpayers have to take can act as screens that make it so that we're kind of screening between taxpayers based on things like their level of tax motivation and other factors. A similar thing might potentially be playing out here. Is there anything else about allowing them that might be problematic? Well, as is true of tax elections generally, there's a concern here about trapping unwary taxpayers, right? That only taxpayers with access to sophisticated advice will benefit. That's true of elections generally. Maybe it's even more true here because this involves making an election that comes into play if certain contingencies play out. So it's kind of even an extra level of advanced planning. Is there anything about allowing these sorts of elections that might be useful? Maybe they have the potential to cause taxpayers to reveal information to taxing authorities. There's existing literature that talks about other ways that tax elections might cause taxpayers to reveal information. Here, the information that might potentially be revealed is the taxpayer's own judgment that what the position they're planning to take is somewhat uncertain, right? This is an election that only kicks in if what they're planning to claim isn't available. So perhaps by filing it, they're saying, look, I think there's some risk that what I'm planning to claim is not available. Whether it will play out that way, you know, how likely it is that the election will reveal information, I think depends on a bunch of different factors. And essentially, if everything over here on the left is true, it's kind of the least likely to be informative in this way. If everything over the right is true, that's sort of the best case scenario as far as it providing information. So, I think that the first factor here is what taxpayers are affected by it. If the tax election affects a wide swath of taxpayers, including taxpayers who don't have access to sophisticated advice, it might not provide much information, right? There will be some taxpayers where the reason they're not filing is simply because they weren't even aware of the election. On the other hand, if all of the taxpayers who are affected by it have access to sophisticated advice, we can rule out that the possibility of not thinking about the election as a reason for why taxpayers aren't filing. The default treatment is also very key. Right? With some tax elections, the default treatment is universally unfavorable. Right? If the election kicks in, you're always better off to have made the election than to have not made the election. In other cases, the default treatment sometimes is more favorable for some or all taxpayers. If that's true, then it's not going to lead to providing much useful information, because even if you have a taxpayer who thinks, well, there's a pretty big risk that my planned tax position won't be available, they won't bother to file, because no matter what, they're better off if the election isn't made. When the election is due is also relevant. So sometimes an election is due fairly early, at a point in time when even the taxpayer isn't in a position to judge whether the position they're planning to take is risky or not. Others are due pretty late, after the relevant transactions have happened. So as an example, in that the taxable REIT subsidiary election that I mentioned, for instance, that's something you generally have to file within the first 2.5 months of the tax year. But the risk that the subsidiary wouldn't be a REIT depends on everything that will also happen over the next 9.5 months. So there might be a lot of taxpayers who it's not that they really think there's any risk that their position won't be available, but they just file it because who knows what will happen for the rest of the year. Others are filed at a point in time after a transaction has happened. The first example I mentioned with real estate, that election is filed after the land was sold. So at that point in time, the taxpayer kind of knows whether they advertise, that sort of thing. On the other hand, there are other features of that election that might make it not very informative, like some of the taxpayers affected by it might not have access to sophisticated advice and so on. And then finally, whether the election is accompanied by features that make filing it costly, right? So some if an election is accompanied by these sorts of features, it's more likely to provide useful information than if it isn't. If it's not accompanied by things like the extended statute of limitations, the requirement to submit a statement, you might end up in a circumstance where just everybody files, right? Because why not? At least if it's a circumstance where the default treatment is unfavorable, if it's pretty easy to file, if filing isn't likely to do much to attract scrutiny by taxing authorities, everyone might just go ahead and file. But if it's costly to file, then we might if all of these things over here on the right are true, we might end up in a circumstance where the taxpayers who tend to file tend to be taxpayers that are taking risky positions, but defensible positions. So to sort of conclude, I think essentially if an election affects a variety of taxpayers, including taxpayers who don't have access to sophisticated advice, I think the best course of action is probably, if there is an election at all, to set it up so that it has a favorable default rule, right? If you don't, if the default rule is unfavorable, you'll end up trapping a lot of unwary taxpayers, and you're not necessarily going to get much in the way of useful information anyway because of this issue up here, where you'll have a lot of taxpayers that just don't file because they weren't aware of the election. But if it comes up in an area of law that tends to universally affect taxpayers that have access to sophisticated advice, maybe this could be a useful tool. It could possibly cause taxpayers to reveal information to taxing authorities and also help to kind of target that implicit penalty so that it applies to taxpayers taking aggressive positions who aren't willing to file the election but not to taxpayers who are taking defensible positions and are willing to file the election. So I'll stop at that point with sharing my screen, and I'm really looking forward to your questions and comments.